You've heard that GDPR increases the cooperation mechanism between DPAs. And of course, in our view, the exchange of information is key here. And the GPEN, in that sense, is a very good platform. It allows the exchange of information and practices among DPAs. We see an added value to be a member of that platform. This gives new ideas and sometimes even crucial information about a specific question with which other DPA might be confronted. To illustrate the need to exchange information, we as Belgian DPA value this in our actions against Facebook. And this is not accurate because it was before the new judgment. The privacy report on Facebook that you can find on our website was sent out to all our EU colleagues. And this has allowed an information sharing on action taken and results obtained by each DPA. It can be seen as a kind of laboratory of ideas. I wanted to underline that to our analysis, the existence of an information sharing system has a positive impact regarding the compliance with privacy principles. And we can here give the example of Google. The creation of a kind of task force within the G20 now Working Party has encouraged Google to be more proactive and compliant with launching new products and services. And that kind of information sharing platform is therefore extremely positive on several aspects. Indeed, due to the evolution of technologies, and also due to the globalization and the fact that now more and more companies are international companies, DPAs, unfortunately, are not yet equal in terms of resources and budget. And it does not make sense to reinvent the wheel when other DPAs has already made an analysis. If we go a little bit further than the simple exchange of information, it goes without saying that enforcement actions are more efficient when they are taken by 28 DPAs. It is true, though, that the current framework has been interpreted differently within the member states, and the DPAs have different traditions. Difficulties arises, therefore, when enforcement action need to be taken. But we hope that with the GDPR, stronger European enforcement could be achieved within the EU first, and then through the GPEN or other instances. And finally, I want to give you an update on our Facebook case. Needless to say that we are disappointed. The decision of the Court of Appeal taken on the 29th of June means that, for us, a Belgian citizen does not have any protection of his or her data from courts vis-à-vis foreign players. This citizen is therefore exposed to massive violation of privacy, and we think this is a very bad signal when it comes to protecting fundamental rights. We are currently assessing the possibility to appeal the decision to the higher level of Court of Cassation. And I have a kind of scoop as well, because my president asked me this morning to inform you that we are currently assessing the possibility to sue Facebook for hacking, because we consider that putting a cookie in non-user equipment could be assimilated as hacking, this will mean a criminal action against Facebook.